month of September last year, and that there have been raids conducted against that particular organization. The atmosphere might be vitiated in the event that the Rashtriya Swayamsevak Sangh undertakes a route march on the 2nd of October, which was the designated day for that particular route march. However, the Madras High Court allowed the RSS to undertake that march subject to certain conditions. There was another bench of the High Court that once again gave the go-ahead. The state government filed an appeal in the Supreme Court against the order of the Madras High Court, and the Supreme Court has now in fact dismissed all the SLPs or the special leave petitions that have been filed in this matter and upheld the order of the Madras High Court. Let me go across to Harish. Harish, take us through the operative portion of the Supreme Court order.
Yes, Siddharth, very important remarks from the Supreme Court bench in the operative portion of the order. While upholding High Court judgment allowing RSS route march, Supreme Court bench says members of the RSS were victims in many cases. Remember, the High Court, the Tamil Nadu government had submitted a list of 29 cases. Out of 29 cases of violence following NIA raids on PFI following ban, it was listed from page 130 to 147 of the document. Supreme Court has said cannot find fault with High Court judgment.
Harish,
in many cases.
Interrupt you because Meenakshi will take us through the operative portion of the order that you've also highlighted. Yes, Meenakshi.
Okay.
We'll come to Meenakshi in just a short while, but the operative portion of the order basically reads that the organization in question in this case was the victim and not the perpetrator. Yes, Meenakshi, you have more details for us.
Well, yes, Siddharth, and that's the moot point here, that the respondent RSS was the victim and not the perpetrator, which is highlighted, of course, in this court order as well. And we'll read it out for our viewers. The court order says, and I'm going to read it out verbatim, as rightly contended by the learned senior counsel, which is Jethmalani in the case, on the side of the respondent being the RSS in the case. The main objective, it says, raised by the state before the High Court was that after the imposition of a ban order on another organization, law and order problems cropped up in certain places, and that the same led to several cases being registered. Then the order goes on to say that the details of the cases are actually furnished in the memorandum of the grounds of special leave petitions, and it says we don't wish to extract in this order the chart provided by the state in the ground. And then of course it goes on to say the name of the petition. In fact, the moot point really here being the fact that in this particular case it was the RSS which was the respondent, and here the respondent was the victim and not the perpetrator. In fact, it goes on to say that the members of the respondent organization, this is the point which we'd like to highlight, were the victims in many of those cases and that they were not the perpetrators. Of course, this is the point which is where the court says the respondent, again as I repeat, RSS in the case, was the victim and not the perpetrator.
Okay, many thanks for taking us through that operative portion. Harish, coming back to you, if you could just give our viewers a perspective on whether or not the route march will be subject to a series of conditions.
Yes, Siddharth, in a way, in the operative portion, in a way, Supreme Court goes on to ask why should victims be punished by denying them the right to do a route march, and for earlier violence, RSS is not to be blamed. They are the victims and not the perpetrators. Their fundamental rights to speech, expression and assembly cannot be denied, and even as the High Court had said, they are inviolable and sacrosanct rights.
The High Court had talked about Article 19(1)(a) relating to freedom of expression. It's a fundamental right in the Indian Constitution. Many thanks, Harish.